us know when you're ready.
We're on the record, Your Honor.
All right. Good afternoon, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting with Judge Mull and Judge Bishop this afternoon on the matter of VOSSBRINCK versus Accredited Home. AC docket number is 43089. We are conducting this hearing over the Teams platform, so everybody is appearing by video conference. In addition, the argument is being streamed live over the branch's YouTube channel, and the audio and visual recording of this hearing will be posted on the branch's website and available to the public. I would ask everybody to keep in mind that although we are not in a physical courtroom, this is a virtual courtroom, and we expect that everybody will observe the same decorum that they would observe if they were in a physical courtroom. I'm going to ask everyone to introduce themselves just to make sure that we can hear and see each other okay. I'll start with the judges, then with Mr. VOSSBRINCK. I'm Judge Bright.
I'm Judge Mull.
And I'm Judge Bishop.
I am Paul VOSSBRINCK, and I do not have a visual. Is that normal?
It is not normal. You should be, so you cannot see us. Is that correct, Mr. VOSSBRINCK?
That is correct. So I'm trying to see what little button I have to push to see that. I see a WB in the middle of my screen.
Right.
And you can all see me fine.
Yes, we can see you fine. So we'll be able to see you during the argument. If you want to, sometimes logging out and logging back in can solve that problem. Now we lost your visual.
Okay, let me try. Okay, now I just clicked something that you should have my visual back on.
Yeah, now I can see you. So,
yeah,
but if
I'm thinking I could turn on my visual, but I don't see how to turn on my visual. But it would be nice to do that.
Well, why don't we do this? If you see at the top, it says leave with a red button on, a red button that says leave. If you,
I see a hang up red button.
Okay. So,
Mr. VOSSBRINCK, do you see a camera on your screen, an icon for a camera?
Yeah. Oh, here I got it now. Yeah. I when I clicked the camera, I lost. You were unable to see me, so I clicked it again. But I can see everybody now. Can you still see me?
Yes, we can. Perfect.
Thank you, Your Honor.
All right. So we can hear and see each other. If at any time anyone's unable to hear anyone, please say so. And if you're unable to see anyone, please say so. If you get disconnected from the conference, please click on the link again and rejoin it. We'll suspend the conference until we know that everybody is present.
Well, I just lost visual again. I had a visual a moment ago, and then I think maybe a button got pushed somewhere, and I've lost visual again. I see the red hang up button, but I'm afraid of doing that.
Okay.
I could try. I was talking to a judge, and then I lost the visual seeing the judge.
Do you see the camera at the bottom of your screen, the icon for a camera?
Oh, I see you again right now.
Well, click that icon. That'll give you your visual.
Well, yeah. Well, now I have visual with you, sir. So I don't know what happened before, but now the camera will be all the way at the bottom of the screen. I'll look for that in the future. But right now, we're very good.
So do you have visual of all three of us?
No, I just had visual of one, and I lost it again. Let me see if I can find that camera that we were talking about.
So I think what's happening is when Judge Bishop is speaking, you're seeing him, but when I'm speaking, you're not seeing me. Is that correct?
That sounds correct. Yeah, right now I'm not seeing. I could do the hang up and try signing in again.
Let me ask our IT person, Sean, what would you suggest?
He's certainly welcome to do that. It may be a bandwidth issue. KARL, are you on wireless?
I have a very fast 1,000 gigabit connection, so I should be good.
Well, if you'd like to leave, you could leave, but make sure you close your browser completely. And when you rejoin, utilize the link from the calendar like we did before when you joined the first time. That's how you'll have to do it.
I hate to impose on everybody that way. I feel kind of all right. Well, I'm going to hang up and try rejoining.
Okay, go ahead. We'll stand in a recess until you rejoin.
It's interesting. Now I see the judge now in front of me. Can you guys still see me?
Yes, I can
Yeah.
see you. Do you see 3 judges?
No, I just see one. I just see you. You're the one who just speaking to me.
Okay. So,
When I speak to you, do you see me now?
Yes, that's funny. I keep on switching between judges. Well, I can live with that if you judges are okay with that too.
that's fine.
Sure.
Okay. This way, whenever a judge asks a question, they should appear in front of you, and then you'll know that they're asking a question. You'll have 20 minutes to make your argument. The appellee has not filed a brief, has not appeared, and will not have any opportunity to argue. So you'll make your 20-minute argument, and then we will take the matter under advisement. So whenever you're ready to proceed, Mr. VOSSBRINCK, you can go ahead.
Yeah, I've lost visual, but I'm very happy proceeding because I don't want to inconvenience the court anymore. And I really filed the appeal more to be able to answer questions that you judges may have rather than present a whole long case.
Okay. I do not have any questions. I understand what your argument is from your brief, and I've read Judge Taylor's decision and the record, so I don't have any questions, but I don't know if Judge Bishop or Judge Mall have any questions.
This is Judge Mall. I don't have any questions. I've reviewed the materials as well.
And this is Judge Bishop. I've read the entire matter, and I don't have any further questions.
Well, then if I may speak for a few moments, and I promise I'll make it quick, I'd like to quickly recap a couple of issues that happened in the beginning of the whole process. It was early in 2000.
Mr. VOSSBRINCK, I'm going to stop you just for a second. I just want to make sure, Lori, when I said before, when Mr. VOSSBRINCK went off and came back on, that we were in recess, I want to make sure that we're still recording.
Yes, Your Honor, we are.
Okay. All right. Go ahead, Mr. VOSSBRINCK.
Yeah, by way of brief explanation, when I was contacted in the early of 2005, a loan agent called me and asked me if I wanted $500,000. And I explained to that loan agent that I hadn't worked in 3 years, and they said that that was not a problem. They would file a loan application that required no verification of income. And I was somewhat reluctant to do that, except my son was recently out of the Navy and I hadn't worked. And in 2005, things were very good. So I decided that I would borrow money and start a construction company. And I did that, not really realizing at the time that it was really predatory lending. Anyone who would give me $575,000 when I had no income, that was kind of a foolish thing. I often tell people that my tombstone was going to read, it seemed like a good idea at the time. But anyway, we did start the construction company, and a year and a half later, in 2007, everything plunged, and I had spent every penny that I had paying mortgages, and was foreclosed. But there was an interesting twist, and I wanted to mention it by way of rather arcane legalese. I had an attorney, a very nice man named Joseph Romanello, for a while, and he went before Judge Matasavage, and he was maintaining that I had a right to rescind my loan because of 15 U.S.C. 1635I. It's a very strange piece of law, and when Judge Matasavage read it in the courtroom, he admitted that he didn't know what it meant and he would rule on it. And I think just by way of kind of an intellectual endeavor, I would like to read what 1635I says, and it's what it says in essence is that we maintained that the right to rescind stopped at 3 years. And when we read 1635I, which I had printed out and had in front of me, it reads in such a way that my lawyer said that the beginning of a legal action by either party prior to the 3-year period of rescission ending, that the clock stopped on that. and that I did have a right to rescind, and I had made about $185,000 in payments and mortgage and things like that. Judge Matasavage ruled against this, and it was a few years later that Senator Robb from Oklahoma actually clarified that, and I was correct, or my attorney Joe Romanello was correct. The clock did stop the minute an action started, so I was thwarted in an attempt to at least retrieve something from the loss of my house. And I feel that throughout the whole process, that as nice a person as Judge Taylor is and always was to me, there was no way in the world that I was going to win the suit. And you'll see in the brief that I filed that even though Judge Taylor had said that my only recourse was to file a new lawsuit, he then later on said that the title had passed and I had no choice. When he did file a memorandum of decision during the Superior Court proceedings, and he filed that memorandum saying that I had no alternative but to file a separate lawsuit, I did so. And in 5 days, that was moved by the defendant to federal court, and Judge Edgerton granted the motion to dismiss, and I filed at the Second Circuit Court of Appeals in New York City. And by the grace of somebody, I met a man online named Bob Katz. And Robert Katz had been to the Supreme Court of the United States, and he helped me prepare a 1,000-page brief, and I prevailed in that. And on the only matter that I brought before the Second Circuit, that Rooker-Feldman did not apply, it was remanded back to Superior Court. And I just knew from the time I was in that court till I filed the appeal that case was not going to go forward, no matter what evidence I produced. And I want to just mention something about an attorney named Jeffrey Knickerbocker, who had been instrumental in foreclosing my loan. Neither Accredited nor Deutsche Bank had the note, the mortgage, the title to my loan when they foreclosed. It was held by the trust, and the only people who had the right to foreclose was the trust or the servicing agent, which was Select Portfolio Servicing. They lacked standing, and the court lacked subject matter jurisdiction. It was void from the beginning. But I also want to mention in this whole process that during the transfer of the title, the alleged transfer of the title from MERS to whoever, be it Deutsche Bank or Accredited, they had no right to transfer the title, and the title would have been null and void anyway. Jeffrey Knickerbocker claimed to be a vice president of MERS while he was representing the defendant. I find that to be a conflict of interest. And then many years later, when my house was finally sold, I couldn't understand how the house could be sold with a federal lis pendens lien on the house. So I went through the court records, unfortunately, just recently, to discover that Jeffrey Knickerbocker had filed a proposed release of lien. That was never signed by Judge Edgerton, nor dated, nor anything else, and yet he filed it in town hall. I consider that to be a preposterous thing to do, to file a release of lien unsigned by a judge. In addition, in the document that he filed, the page right after the page that the judge did not sign, I have Judge Edgerton's memorandum or statement about the request, and twice he declared it moot. He said the case was closed, and he did not rule that the lien should be released. He said it would have been remanded to Superior Court. Why anybody would file a release of lien that was unsigned is beyond me. It is filed on book number 675, page 1221 in the Southbury Land Records. It befuddles me. And then in the following page, I don't have my glasses on, but on page 1222 of the same volume, Judge Edgerton clearly says that the issue is moot. I have no idea how things like this happen. I believe that I wrote my appeal as best as a layperson can. I believe I made my point, and I appreciate the time that you've given me to speak my piece. And Your Honors, I thank you for your time, but I really have said all that I can say.
All right, I don't believe there are any other questions. Thank you very much, Mr. VOSSBRINCK, for participating in the virtual courtroom with us today. We'll take the matter under advisement. We will decide the case as we indicated in our notice based on the record and your brief and your argument here today. And we will stand adjourned until 9:30 tomorrow morning. Have a good day, sir. Thank you.
I thank you for your time, Your Honor. Have a good day, and please be safe.